Hey everybody, greetings. I'm so delighted to see everybody here. It's really important, I think, at times like this for us to gather and share our ideas and our feelings and our understandings of what's happening. My name is Leslie Salzinger. I'm Associate Professor of Gender and Women's Studies here on campus, and I'm a member of the Berkeley Faculty for the Freedom to Learn and of BFA. And today's event was co-organized by those two groups and also by UC-AFT. And that really, I think, gives us a sense of the breadth of the concern across campus about academic freedom, and especially about academic freedom in our classrooms for all of us. No doubt, like many of you here today, when I heard that the Berkeley campus had released the names of 160 faculty, staff, and students to the Office for Civil Rights at the Trump Department of Education, I was in equal measure appalled and confused. Appalled because how could my workplace engage in what seemed to me to be such a deep violation of privacy? And especially, how could a university fail so profoundly to defend the academic freedom so fundamental to our mission as an educational institution? And I was also confused because I rather figured my name would be in there somewhere, and I and many others I knew didn't receive such notification. So what was the logic of that release? And both of those responses were only deepened when I discovered that the rest of the UC system had released many more names, and other campuses had not even had the integrity to tell those whose names had been released that that had taken place. So what was the background to this decision? What was its internal logic? And most importantly, how might we, as faculty of this institution, work to protect those named and ensure that this would not be repeated? Today's panel is an attempt to respond to those questions on my part and that of many others. The three panelists we've invited to speak today are all lawyers with deep knowledge about this set of issues and very distinct relationships to the release of names itself. I hasten to say, however, that our goal in inviting them was not to learn about the legal background and just leave it at that. We simply cannot teach generatively and with integrity when we are always looking over our shoulders, concerned that a malicious complaint would send our name to the federal government that clearly does not have freedom and equity at its heart. Given that, our aim is to learn enough about that legal and regulatory history and background to grapple with how to respond to the ongoing threats to our capacity to do our jobs. Responses go beyond court filings, of course, and that is why you can see at the back of the room that we have a table for Berkeley Faculty Association and for AFT, and they are hard at work on these questions, and we really encourage you to go back there, to talk to them, to sign up at the end, or to do that quietly if you have to leave early, but do not leave without giving them your name if this is a set of issues you are interested in working on. As members of the Academic Senate and as teachers of our students, our job is first to understand the background, but then, most importantly, it is to figure out together what we're going to do about it. I'm not going to go on. We're here to learn from those with much more knowledge than I. So here's the agenda. First, we're going to hear briefly from Zoe Hamstead, Associate Professor of City and Regional Planning, mostly here and also actually Chair of BFA, but she's speaking right now in her capacity as the Chair of Legal Affairs for the UC-wide Council of Faculty Associations. After Zoe speaks, Zoe will give us a brief rundown of what happened locally and at the UC around the name relief and the many challenges that have been mounted from both BFA and KUFA about that. Following Zoe's summary, we will hear from the three panelists. They'll each speak for 10 to 15 minutes. We'll take another 10 to 15 minutes for them to speak to each other, and then we will open it up for questions and discussion by those in the room. I'm going to briefly introduce the panelists now so that we can just go ahead and not be interrupted during the discussion. And one last thing I want to say is this part of the panel, this is being taped, so the panel is being taped right now. But once we turn to the discussion, we'll turn off the cameras and the taping so that we can have a more open discussion here in the room. So, with no more ado, our first speaker is Lhamon. She's the inaugural Executive Director of the Edley Center on Law and Democracy here at UC Berkeley. She's come to Berkeley after a long career working in the executive branch around civil rights, and especially important for our questions today, she served as the Assistant Secretary for Civil Rights at the US Department of Education under both Biden and Obama, leaving that role only last January as Trump entered office. The OCR is the same institution that is using its regulatory role to demand names today, so her perspective is especially significant. Brian Soucek is the Martin Luther King Jr. Professor of Law and Chancellor's Fellow at UC Davis. He's the author of many books and articles, but most relevant for us today, he's the author of The Opinionated University, a really great title, which is due out with U Chicago shortly. He's also former chair of Davis's University Committee on Academic Freedom and currently a member of the AAUP's Committee A, which deals with academic freedom and tenure for the AAUP. Last but not least, Asli Bali is the Howard M. Holtzmann Professor of Law at Yale Law School, and she'll be joining us here on Zoom. She's very widely published as well, both in major law journals and in the public press, and very and relevant, obviously, for what we're doing today. She's also president of the Middle East Studies Association of North America. Before teaching at Yale, she was at UCLA, so she's also part of the home team. Most crucially for our purposes today, during her tenure at the Middle East Studies Association, she received a set of grants enabling MESA to collect data on academic freedom in its defense, again giving her expertise precisely on our subject today. So before finishing, I just want to thank the English department for generously allowing us to use this space, and Colleen Lyon and Amanda Goldstein for facilitating that, and last but not least, John McChesney-Young and Annika Law for helping us out with the tech, which otherwise is very daunting. And of course, many thanks to our panelists. So,
in my role as the Council of UC Faculty Association's Chair of Legal Affairs, I'm responsible for coordinating legal actions across the faculty associations on all 10 UC campuses. So what I want to do is just spend a couple of minutes contextualizing this conversation in the ongoing federal attacks on the UC and on higher education that we have been fighting in CUCFA, the Council of UC Faculty Associations, and Berkeley Faculty Association. Some of you may recall that in March earlier this year, UCOP disclosed over 850 UC faculty members' personal and demographic information in response to a subpoena from the US Equal Employment Opportunity Commission as part of its Title VI investigation of anti-Semitism on UC campuses. Several days before the Council of UC Faculty Association wrote a letter to UCOP expressing our outrage over this privacy breach, the American Association of University Professors, or AAUP, had published a legal analysis on why personally identifying information is not generally relevant to Title VI investigations and how its disclosure could violate constitutional rights. Around this time, universities including Columbia, Harvard, and Brown were receiving demand letters from the Trump administration that made federal funding contingent upon sweeping programmatic changes. Abolishment of, for example, Columbia's independent body responsible for disciplinary decisions, hiring special officers who can remove people from campus or arrest them, changes to hiring and admissions policies, etc. It was then, around April of this year, that the Berkeley Faculty Association began organizing with CUCFA and with AAUP in anticipation of a similar demand letter that we worried would soon be issued to the UC. Finally, on August 8th, that demand letter arrived to UCLA, following the Trump administration's freezing of over $500 million in federal funds.
It's not your fault.
The full list of demands in that 28-page letter are not known to us because the UC has denied our Public Records Act request to disclose it. We've been fighting that in the State Superior Court in Oakland over the last month. But because the letter has been leaked to some reporters, we know that it calls for many of the same programmatic changes we've seen at Columbia, Harvard, and Brown. It calls for things like enforcing a binary gender system, refusing admission to students who harbor non-Western ideologies, and a host of other deeply problematic practices that are antithetical to free expression. On September 16th, all 10 faculty associations and KUKFA joined together with AFT, with AAUP, and 7 other unions representing over 150,000 students, staff, and faculty in suing the Trump administration to have the demand letter vacated. How does all of this relate to the 160 names disclosure that we're here to hear more about today? If you read the letters that AFT, BFA, KUKFA, and AAUP have written to our Chancellor and to UCOP in recent weeks, it will be apparent to you that we believe the release of personally identifying information was improper and should not have been past practice, even in a different political climate. I'm not here to elaborate on that. The panelists are here to speak to this issue. But the point that I want to add as framing to this discussion is that it is by no means outside the realm of possibility that named individuals who are part of our community, including many students who have been named, could get used as bargaining chips in these negotiations. And so it is especially important to be having this conversation in this moment and to be using every power we have to protect individuals in our institutions from these attacks. The release of personally identifying information right now is linked to this broader attack on higher ed that our organizations have been fighting. And this conversation for us is in some ways a first step in educating all of us on what has transpired so that we can start to identify how to collectively move forward. So I just want to express huge gratitude to the panelists for being here and sharing your expertise with us, and to all of you for being here. It means so much that you care about this issue. Back over to Leslie.
Thanks to all of you. I'm going to hope not to echo too much talking at you. I want to start just by saying what I know about what is happening is what I have read in the news, what came from President Milliken's statement, most recent statement, and the FAQ he attached to it, and what I know from my time leading the Office for Civil Rights at the U.S. Department of Education and the relevant law there. So I have no other insider information, but I'm going to share with you what I do know, and you will do with that what you will. So I understand first from intrepid reporting from the Daily Californian, which reported on September 10th, including a screenshot of a notice that went to an affected person, that sometime before September 4th, the UC system-wide Office of General Counsel made a decision to share with the Office for Civil Rights at the U.S. Department of Education information that included the names of persons involved in reports that the University of California, Berkeley had received regarding allegations of anti-Semitism, and that was responsive to an investigation opened last spring that seeks files and reports related to alleged anti-Semitic harassment and discrimination. Just to say it, the Office for Civil Rights at the U.S. Department of Education has both statutory and regulatory authority to seek that information, and it is very common for OCR to seek it, and in fact, I sought it all 8 years that I was there. So it is, this is a very common practice from the Office for Civil Rights. Just giving you some background on that, Congress created the Office for Civil Rights at the U.S. Department of Education to enforce Title VI of the 1964 Civil Rights Act, and later Title IX of the Education Amendments and Section 504 of the Rehabilitation Act. Those laws protect against discrimination based on race, color, national origin, sex, and disability. And they promise, all of us, that no person shall experience discrimination on those bases. So it's a very serious charge and a very serious promise that the office is charged to investigate. And its regulatory charge is to investigate, quote, whenever it has information that the law may have been violated. So when it is doing its job, it's not picking and choosing its cases. It is investigating any case where it has information that the law may have been violated, and it investigates that fully. And that means that its responsibility is to get the information it needs to assess that question. OCR does not have jurisdiction over religious discrimination, but it has long interpreted its jurisdiction over national origin discrimination to include jurisdiction over allegations of shared ancestry discrimination, which means, in short, discrimination alleged to have occurred based on stereotypes about a region of the world that someone comes from or is perceived to have come from, or style of dress, or accent, or language spoken that may relate to national origin. And that covers shared ancestral or ethnic characteristics that are tied to Jewish, Muslim, Sikh, Hindu, Israeli, Palestinian, Arab, or South Asian identity, among many others. Very broad jurisdiction, and it promises that no person will be discriminated against on that basis. So for these kinds of investigations, the Office for Civil Rights is generally evaluating whether a university or a school district responded as required by law to notice of discriminatory harassment that is so severe or pervasive that it limits or denies a person's access to education. That means that the Office for Civil Rights is evaluating whether a hostile environment exists based on shared ancestry, and if so, whether, in this case, a university promptly took steps that are reasonably designed to end the hostile environment, prevent its recurrence, and if so, whether those steps were effective. So there's a lot of information that the office needs to be able to make that determination. And also, just to say it, the office investigates whether a university unlawfully treats persons differently from other persons based on national origin, real or perceived. So here's the statutory authority, and I'm going to give you a bunch of sites just so we all have them. But the Department of Education Organization Act, which is the act that created the U.S. Department of Education, provides that the Assistant Secretary at the Office for Civil Rights, whom I was, is authorized to collect or coordinate the collection of data necessary to ensure compliance with the civil rights laws within the jurisdiction of the Office for Civil Rights. For those who care, that's 20 U.S. Code 3413C1. And OCR regulations require recipients of federal funds to maintain records sufficient for OCR to ascertain noncompliance or compliance. And that is 34 CFR, Code of Federal Regulations, 100.6 for Title VI, which is what's relevant here. I understand that people also have privacy-related questions, and I am not a privacy law expert, but here are things that I do know. First, the Family Educational Rights and Privacy Act, which is FERPA, permits the U.S. Department of Education access to student and other records for purposes of enforcing legal requirements. That's 20 U.S. Code 1232 GB1 and 3. And under the FERPA regulation, prior consent is not required for disclosure of student education records to the Department of Education or to the Department of Justice or to state and local education authorities. It may be unwelcome news, but that is the law. It is required to any other agency. So in the federal government, it's the Department of Education and the Department of Justice, where prior consent is not required. We issued, when I was still at the Office for Civil Rights, a privacy frequently asked questions document last December. And I was interested to know last night that it's still on the website of the U.S. Department of Education, which means that the U.S. Department of Education is holding it out, is still accurate about their practices. Here are some things that it says. It says that the Office for Civil Rights generally only uses personally identifiable information for civil rights enforcement activities. It also says that OCR generally only discloses personally identifiable information externally, consistent with the Privacy Act, FERPA, and FOIA. And it says, this is question 11 in it, that OCR generally does not disclose personally identifiable information to other government entities unless necessary for investigation or enforcement related to the civil rights laws that OCR enforces. So I emphasize that. It also says that disclosure will only be made as consistent with the Privacy Act, FERPA, and FOIA, which may not be all that comforting given what I just said about what those laws require. The Privacy Act. The Department of Justice website still says that the Privacy Act does permit disclosure of personally identifiable information to another federal law enforcement agency for law enforcement purposes. That is, the law is, that a record may be disclosed to another agency or to an instrumentality of any governmental jurisdiction within or under the control of the United States for a civil or criminal law enforcement activity if the activity is authorized by law and if the head of the agency sends a written request. I imagine that's wildly not comforting, but again, the law. And the Department of Education regulations permit disclosures of records for this purpose and also to Congress without limitation. That is 34 CFR 5B.9. So, having given you the law, comforting as it is and isn't, we return to Berkeley's specific situation. As I understand it, the Office for Civil Rights in the current administration requested data from Berkeley about notice Berkeley received of anti-Semitic discrimination and how the university responded. Typically, that would mean asking for all case files that the university holds regarding such notice. And those case files include names of affected students and staff. It's generally not essential for the Office for Civil Rights Investigations to see those names. And OCR, to perform its civil rights law enforcement function to uphold the law, is looking for how the university responds to allegations of discrimination. I have lots of thoughts and lots of examples for what that work looks like, and I'm glad to come back to that if we have time. But for now, it's maybe enough to know that I very strongly believe that OCR does need to review university files and documents regarding notice it receives of alleged discrimination and how it responds. OCR cannot fulfill its truly beautiful function to ensure that no person is subject to discrimination if it cannot look at those records. So when I opened investigations, again for 8 years for 2 presidents, I asked for that disclosure because I thought it necessary. And for example, the system-wide University of California resolution agreement entered into last December related to shared ancestry, when I was still there, does include a requirement for provision of records with that information regarding specific universities, not Berkeley, in the UC system to ensure that the Office for Civil Rights can tell that the university fulfills its obligations. Having said those things, I will also tell you that most of the time I cared not at all whether the particular university anonymized names when we made those requests. And generally, if a university or a school district asked to anonymize names, we agreed to it. And the times we did not agree to it were times when we had specific evidence that a university or a school district was not providing us records that we were asking for. And we would know that, for example, because somebody else had given us a copy of an email sent to the university that didn't come in its provision of records to us. Or when the school system's efforts to anonymize records were going to take so long that we couldn't get access to their information. So if it was an unjustified delay tactic, or if we had a reason to think that a university or a school district was not providing us information within its control, we would insist that we have just the complete records and complete access. But otherwise, when we asked to anonymize, we allowed them. And just to say it, I know with certainty that it is still possible to anonymize those records in the Trump administration to OCR now. I know that because the current complaint processing manual that the Office for Civil Rights updated in the Trump administration says that it will allow a recipient to, for example, replace specific names with the code unless doing so impedes a timely investigation. So they advertise, they will still take it. Also, I know, as a reader of news, that the agreement that the Brown University entered into with the current Trump administration allows for the anonymous provision of records without names, also saying that OCR may require the complete provision if it deems it necessary to complete its monitoring. So I think all that information was available to everyone, not just people with specific expertise in the Office for Civil Rights. I also know from reading the frequently asked questions document that President Milliken recently circulated that it says in the first item that the university sought to anonymize names and the federal government denied that request. Left unsaid in that frequently asked questions document is that the university system must have thereafter decided not to challenge that denial, either affirmatively or in response to any enforcement action that the federal government might have taken. That choice reflects an assessment of litigation risk and federal government reprisal risk, not a fulfillment of a legal obligation. And I think that's important for us to remember. There are available arguments, even if the federal government insists that it does need the name-specific information to challenge that provision. And this university system made the choice not to go that route. That is a risk assessment decision, not a decision to fulfill a mandatory legal requirement. Just to say what we all have available to us. It's been reported in the news last month, for example, that the Maine Principals Association is fighting a subpoena from the United States Department of Justice that seeks names of all students playing interscholastic sports in Maine, because the Maine Principals Association is concerned about the legal risk to transgender students and their families who would be identified responsive to that subpoena. We know from the frequently asked questions document from President Milliken that the University of California system is aware that providing names to the Trump administration may place named persons at risk. The FAQ is explicit that the UC system sought not to disclose the names. That means they understood that it was risky, so to do. And we know what kinds of risks the UC system may have known to worry about. Just to say it, a Massachusetts district court judge ruled this month that the Trump administration's effort to deport non-citizens for their pro-Palestinian activism violates the First Amendment. So we don't have to wonder if there's activity that we might be concerned about that could take place. I'm going to stop here just by saying I would want this university to stand for justice, protecting our people from known risk rather than handing over names. And I do know that that was possible.
It's been difficult to answer questions that people ask about whether the choice that the university has made about disclosures was correct or not, given that we have no idea what the request was, what the scope of the investigation is, and what the university might have said exactly in terms of its counteroffer, its refusal to hand things over. We don't know the extent to which the original offer has, the original demand has been narrowed. And that's part of the larger transparency problem here. There's an irony that after several years now of an increasing centralization in response to events on our campuses, in response to protest, for example, where we now have centralized demands for time, place, and manner regulations, where we have demands from the legislature going through UCOP that we will make freedom of speech, freedom of protest, such as it is, policies to fit certain system-wide requirements. That, by the way, parenthetically, is a very strange example of a strange candidate for a unitary response, given that the very nature of these kinds of regulations, time, place, and manner regulations, are meant to be tailored to the environment, to the speech environment, such that what you deal with here at Berkeley is a quite different thing from what we deal with in our more rural environment at UC Davis, where I teach. And so it would be strange for us to have the same kinds of regulations of speech at both places, in fact, across all 10 campuses. So we've seen this increased centralization time and time again, until this particular case, where you all have heard something about what's happened here. We've heard nothing at Davis. We have no idea. And so whatever response that we're getting from the Office of the President, that Catherine was just referring to, the FAQ, the statement from President Milliken, of course, only talks about Berkeley. Is that because Berkeley is the only one affected, or is it just implied there that UCOP will only respond if there are the kinds of journalists mentioned that are able to find out about a problem on a specific campus and then have a faculty that demands that response? In any event, these issues of transparency make it incredibly hard to evaluate whether we think the kind of cost-benefit analysis that Catherine was talking about, such that whether we think that pushing on a particular thing might have had any possibility of success or not. One thing I do think, among the things centralized in recent months during this administration, is certainly UC's legal response and its response in terms of public statements to the threats from the federal government. So what used to be a real federalized system of exploration, of experimentation with different campuses going different ways, having different responses through their campus council, those choices are all going through UCOP at this point. And from UCOP, not necessarily staying with the General Counsel's office, but going to the variety of law firms that the University of California has hired precisely to make the kinds of cost-benefit analyses that we were just hearing about. I wish I had more confidence that those lawyers, not ours, but the ones that we're outsourcing things to, had a stronger sense of the very distinctive kinds of costs that we experience in an environment like this. And those are costs to freedom of expression and academic freedom. So the chilling effect that we were just hearing about, of course, is a far different thing when it's us giving the response versus the main public schools giving a response, much less a normal EEOC type investigation where it's just a private company. And I worry that those kinds of costs to our distinctive speech environment in this type of context aren't fully the thing that these corporate lawyers are always as attuned to as I think we are on the campuses. I also worry that as the lawyers representing UC, they might also not be as fully attuned as we might hope for the sector-wide effects of these kinds of disclosures. By sector-wide, I mean higher education as a whole. The way that Harvard, to the extent it has stood up, that we, to the extent we have stood up, provides cover and changes a narrative about what's happening in higher education more broadly. I hope that that's being weighed in the cost-benefit analysis that's going on. But let's just assume for a second, for the sake of argument, that that the cost-benefit analysis was done in a way that we approve of and that UC really made the right choice in disclosure. That's of course not the end of the story. There's more to the story in terms of the lawsuits that the AAUP has brought along with GUCFA and other unions. Those are crucial. They're crucial not only because they don't depend on waiting for the institution itself to sue, but as we've seen in the case of Harvard, they're crucial because even when the university does sue, as Harvard did, having the AAUP, the local AAUP at Harvard, filing its own lawsuit means any kind of settlement by Harvard isn't the end of the case. There is another case that they're bringing where they're pursuing. Now the interest in the two cases and there might be some differences between what the faculty has standing to allege versus what the institution itself does. Although there might also be ways in which that's helpful. Those of you who have grants from the federal government that Dean Chemerinsky here has been suing, among other lawsuits, to protect. There's a class action that has so far been successful there. And part of the way in which it's been successful is by saying, these aren't just the kind of contract disputes that the Supreme Court has recently been shoving off to this obscure court of federal claims in Washington. They can't be contract disputes because you all aren't the parties to the contract. The University of California is. And so there's a different set of considerations when we have these lawsuits that are being filed that we were hearing about before. They're crucial. Lawsuits like AAUP versus Rubio, Catherine mentioned about the ideologically based deportations, so far have been successul. And those are the kinds of things that even if the disclosure was appropriately sought and was proper if those disclosures were proper, so many of the worries that you justifiably have about the disclosures are based in things like the Trump administration is going to share this information with immigration and it's going to be used, put to improper purposes. And so suing directly to stop those improper purposes is of course crucial. But then I just also want to urge you to look inward as well, because much of what we're also worried about, aside from, let's say you don't have immigration worries, you're likely worried that there are going to be people in the public or in the government that are going to demand your firing, that are going to demand discipline because of things that are revealed in these files. They're going to leverage the fact that any number of students have complained about things said in your classes or things that you said on the quad, and that they're going to leverage that into calls for the shutting down of departments, for the firing of professors, etc. And we have tools internally to stop that. And we have to be vigilant in both our knowledge of them, increasing our knowledge of what the university can and can't do in that regard, which is to say the academic freedom and constitutional free speech protections that we all have. And we need to be equally vigilant, especially right now at a time when those exact policies are under system-wide review, as you may or may not be aware. If you're not aware, I urge you to become aware. Go onto the the website at the Academic Senate that says what's up for system-wide review, and take a look at the policy that is currently out for all of you to comment on, in which the Board of Regents has asked the Senate and the administration to revisit the question of disciplinary procedures for what they're referring to as faculty expressive activities. I think there's an opportunity. I want to say something positive here. I think there's a real opportunity in this revision, not to change the policies we have, but to be explicit about the protections that are already there. So for example, in our academic freedom policy, APM 10, it explicitly says that the principles of academic freedom protect freedom of inquiry and research, freedom of teaching, and freedom of expression and publication. Now, you're familiar with the kinds of protections you have in the classroom or when you publish something. But what's not explicitly listed there is extramural speech. Any possible discipline you might incur for something you say off the job. Or for that matter, intramural speech. Any discipline you might, any chilling effect you might feel about speaking up within shared governance, or even outside of it, in things you might say about the University of California in public. Those aren't explicitly mentioned there, but let me just read to you from your former colleague, Robert Post, who wrote APM 10. When that was distributed, when that was adopted, Professor Post's statement there wrote, "The freedom of expression and publication refers both to the right to speak in public as a scholar and to the right to speak in public as a citizen. It refers to the right to speak within the university as a participant in its, it also refers to the right to speak within the university as a participant in its affairs." So the materials that everybody voted on when APM 10 was adopted, it included an explanation that what is written there includes both extramural and intramural speech. And the background documents, the guidance documents that were circulated as part of this APM 15-16 process, the discipline process for expressive activities, for the first time to my knowledge, make explicit this fact that extramural and intramural speech protections are included under APM 10. That to me is a wonderful, wonderful thing, because those protections are better than what we have under the Constitution. We have both, but our policy protections go beyond it, because our policy protections say that protection is the default, and the only way that there's some kind of exception is if something is said that is so incompatible with your job, with our jobs, with the university's mission, that it shows you unfit to continue doing the things that we do, to continue in the profession. That is, those words themselves are not UCs, they are the AAUPs. But the relevant policy here at UC, APM 15, is explicitly based in every particular on the AAUP's statement of ethics, which in turn incorporates its previous statement on extramural utterance. So the quote that I just gave, although it's not written down in any UC policy, is, I think, I have not heard an argument why that is not the standard here as well. And so my goal during this period of revision is to make that as clear as possible, so that going forward, if you do experience threats, if you do experience the very chilling effects that these kinds of disclosure might have, that you know exactly what the protections are, and that there's agreement within the system that those protections are as strong as I think they currently are. Thank you.
Okay, can you hear me?
Yes.
Great. So I was invited to speak at a much more general level, not Berkeley specific or UC specific, although I am love the UC system, miss my old home at UCLA greatly, and I'm so delighted to be with you in your time zone, even if it means sitting in my office at almost 8 o'clock at night out here on the East Coast right now. But I am here more on behalf of the Middle East Studies Association and the kinds of work that we've been doing, and I just want to explain a little bit what that is. Obviously, from our name, we are a scholarly association. We have thousands of members. We're the largest association of scholars studying the Middle East, which are scholars in the social sciences and humanities overwhelmingly, but including law professors like myself. And we have been in the crosshairs for a variety of reasons as scholars across the country since October 2023 in the ways in which anti-discrimination rules, generally enforcement actions, and the Department of Education's Office of Civil Rights actions have really undermined both academic freedom and freedom of speech, and I'll explain how that's been the case and why, what the patterns have looked like. But one of the things that we have done in protection of our members, and by the way, I should say jointly with AAUP in many instances, including AAUP v. Rubio, where we are the other associational and organizational plaintiff in that case, and actually the one that was able to establish standing. I sat in that trial for 2 weeks in July before Judge Young, the federal judge in the District of Massachusetts, who issued that decision last week, which I think does incredible work in explaining the empirical context that we are dealing with at the national level. But in any case, together with AAUP or on our own, we've been trying to take protective actions to address the kinds of vulnerability our members now face. And one prong of that has been to address the kinds of transparency problems Brian just spoke about by undertaking data collection to create, offer some sunlight as to what the patterns are and what we've been seeing in terms of discrimination across the country. Our first report on the basis of this kind of data collection is going to come out later this month, but we also have put out some blog posts and given information to some journalists over the course of the last couple of months as we've been collecting information. And much of what I'm going to share with you now is also described in more detail in a blog post by my colleague Daryl Lee, who is one of the co-chairs of our task force on civil and human rights at MESA, and he published a blog post detailing some of our data in the Law and Political Economy blog, which you can take a look at if you would like to. What we know about anti-Semitism investigations in particular since 2023, which is what I was asked to speak about, is the following. 25 anti-Semitism investigations of post-secondary educational institutions were opened in the last 2 months of 2023, which is to say more anti-Semitism investigations in those 2 months than in all previous years combined in the work of the Department of Education's Office of Civil Rights. That was followed by 38 additional investigations in 2024, and 2025 is on pace to be a record-breaking year again. And so we have a massive increase in the number of Department of Education investigations and the number of post-secondary educational institutions that are under investigation for anti-Semitism since 2023, and that is now further magnified by other federal investigations, particularly by the interagency task force that was created by the Trump administration that is moving forward in what we're going to call Title VI adjacent investigations that use the language of Title VI but are not grounded in authorities in Title VI and are not limited in the ways in which Catherine described the work of the Department of Education's Office of Civil Rights. They are far more all-encompassing in the case of the interagency task force, which is being run at this point, we believe, through it includes the Department of Homeland Security and the Department of State as well, but it seems to be run primarily through Health and Human Services. One of the elements of this pattern of record-breaking anti-Semitism investigations is that they were triggered by the explosion of campus protests following the October 7th attacks that began Israel's military action in Gaza over the course of October 2023. And many of these investigations have recast campus protests against Israeli state policies and actions as discriminatory harassment against Jewish students or Jewish communities. And they've done this by building on 2 earlier trends, the first of which Catherine already mentioned, which is the Department of Education's expansion of Title VI to include some forms of anti-Semitism, not as religious discrimination, which is the traditional way in which anti-Semitism was addressed as a First Amendment violation, as religious discrimination, but rather under the rubric of shared ancestry, as she described. Now, this isn't something that has been the case since Title VI came into force. This is something that occurred over the last 20 years, and it occurred as a result of determined advocacy inside the administration and out, under the Bush administration and since, to incorporate mechanisms through anti-discrimination law to go after criticism of Israel. So the first is the expansion of Title VI to include some forms of shared ancestry, as Catherine described, forms of anti-Semitism. And the second trend that these investigations have built upon is pro-Israel advocacy nationally that normalized the conflation of criticism of Israeli state policies and actions with anti-Semitism, specifically by pushing through a controversial definition of anti-Semitism, the International Holocaust Remembrance Alliance definition. I won't go into it here. I'm sure most of this audience is quite familiar with that definition by now. But these two moves, first, the introduction of shared ancestry-based anti-discrimination investigations under Title VI, and the second, redefining anti-Semitism to encompass criticism of Israel. These two are the pillars of this expansion of anti-Semitism investigations since 2023. Now, the same ecosystem of pro-Israel organizations that were involved in establishing those two pillars in the first place, redefining Title VI and also introducing the broad definition of anti-Semitism to encompass criticism of Israel, have also been involved in driving the surge of complaints to the Office of Civil Rights. So we've taken a look at the 90 publicly available complaint letters that result in investigations. And in those complaint letters, what we have discerned is a clear pattern that it is primarily criticism of Israeli conduct or policies that is being coded as anti-Semitic harassment in the complaints themselves. Just to give you a sense of what I mean when I say the ecosystem of pro-Israel organizations have been involved in the driving of a surge of complaints to OCR, a single right-wing journalist instigated 15 of the investigations of the 90 complaint letters that we looked at. 25% of the investigations overall originated from people with no relationship to the school in question in the complaint. And none of the complaints seem to require any specificity of evidence to merit investigation. So just as one example for 2023, we reviewed a complaint letter in which a complaint against Cornell that resulted in an investigation was based on a single substantive paragraph, which that paragraph alleged that there was a professor on that campus that advanced hate in a variety of ways and was a supporter of Hamas and their beliefs, not adducing any evidence at all, not indicating any concrete way in which the named professor could actually be determined to be doing any of the things that were described in that paragraph. All of this is, we've made already available if you want to take a look at that blog post that I mentioned. Now, why would OCR or Title VI be used for these purposes? Why is it particularly susceptible to this kind of use? And the answer to that is because the structure of Title VI enforcement can lend itself to abuse for one very simple reason that was alighted upon by one of those pro-Israel ecosystem advocates, a conservative lawyer called Kenneth Marcus, who was one of the pioneers of the strategy I've described and was also personally involved in both the introduction of the shared ancestry ground in Title VI generally and in the introduction of the IRA definition of anti-Semitism in the work of the Department of Education and generally speaking the federal government's activities. So Ken Marcus publicly commented that getting caught up in a civil rights complaint is not a good way to build a resume or impress a future employer. That's quite right. The reputational harm that is done when a complaint is filed, even when that complaint is determined to be unfounded, is difficult to overstate. For one thing, for the reasons that both Catherine and Brian have described, the complaints are against institutions, but the persons that are caught up in the complaint are individuals. And those individuals have no straightforward way to formally respond to a complaint or clear their name once it moves to the OCR level, because the OCR investigation is of their institution and not of themselves, and they don't have a direct stake or capacity to enter into the process that is triggered by the investigation. Of course, the same reputational harm problems mean that institutions have very strong incentives to find ways to enter into voluntary resolution agreements, again, regardless of the merits of the underlying complaint, that is to say, regardless of the strength of the evidence, if any evidence is adduced at all, to the complaint. And so if a mere complaint, including complaints driven by actors that have no connection to a campus, in one instance, as I've already mentioned, a single individual initiating 15 complaints who is a journalist outside of any campus, is sufficient to trigger an investigation in and of itself. And that investigation has the structural characteristic that will produce this kind of reputational harm, both for institutions and for individuals, then you can see why an ecosystem of advocacy that wants to silence protests on campuses would seize upon this infrastructure. But it's not just the reputational harm. There's a second element, to the structure of Title VI enforcement that lends itself to abuse, and that is jawboning, which is to say a circumstance in which the government may engage in regulatory activity, which itself then induces third parties that are being regulated to crack down on otherwise protected speech in ways that would be a violation of the First Amendment if undertaken by the government directly. And so what the government has done, particularly with respect to private schools, is essentially induce them to crack down on otherwise protected speech, disciplining faculty, particularly precarious adjunctified faculty, but also in some cases even tenured faculty, as in the notorious case of Maura Finkelstein, who was terminated by Muhlenberg College merely for speech acts. So people are facing massive punitive disciplinary consequences from their institutions as those institutions try to avoid or mitigate the reputational harm that they are suffering as a consequence of the initiation of these investigations and as a consequence of the kinds of pressure they've been brought under not only by the Department of Education, but also by Congress and other mechanisms of investigation that have been triggered in an attempt to clamp down on speech on campuses. Now, Title VI investigations typically end in voluntary resolution agreements, again, as Catherine described, in which schools themselves agree to take measures, and often these measures go well beyond what could otherwise be directly required by the government, because they have chilling effects on speech that if the government were itself directly requiring particular measures might be subject to constitutional scrutiny. But when campuses voluntarily, consensually agree to them, they, of course, thereby correct for the constitutional vulnerability to further scrutiny. So, for example, over a dozen schools entered into such resolution agreements with the Biden administration in 2024, and we've taken a look at what the common features of those kinds of resolution agreements are, and they overwhelmingly police campus speech on Palestine, shifting policies in ways that multiply avenues for generating new, often anonymous grievances, and inviting even further crackdowns. They include introduction of government-approved mandatory trainings around anti-Semitism and, as a footnote, anti-Muslim, anti-Arab, anti-Palestinian. We can talk about this in the Q&A for those who are interested. There's been a recent controversy at Northwestern, some of you may have seen, where students have refused to participate in the trainings because the trainings themselves are dependent on, first of all, deeply anti-intellectual, in the case of the Northwestern training, assertions and distortions of history, and require more or less ideological commitments to be entered into by those undertaking the training in order for them to complete the requirements of the training itself, agreeing to definitions of anti-Semitism or to treating conduct as anti-Semitic that they regard as protected First Amendment speech. The resolution agreements also often require distribution of campus climate surveys that elicit anonymous complaints without requiring corroboration. So this is an example of ways that you might multiply circumstances in which anonymous speech results in further investigative authority or further allegations that may themselves generate new forms of investigation. Some universities, including the University of California, have pledged to require campus police to report allegations of discrimination. Note, I said discrimination, not harassment, to relevant university authorities. This blurs the line between conduct that may or may not be subject to disciplinary regulation with conduct that is subject to criminal proceeding, conflating discrimination with harassment and implicating the police on these campuses in the policing of speech. These resolution agreements have also involved turning over spreadsheets detailing every internal discrimination complaint, including names of accusers and accused, and often others, by the way. This is something that was not covered in the discussion that we just had about privacy, but in other cases, outside of UC Berkeley, there have been so many cases of institutions turning over names. We've documented instances in which the names that have been include people who were CC'd on emails that were discussing complaints, or people that were serving as faculty advisors of individuals in complaints. In other words, just bystanders or individuals that get caught up and have their names disclosed, not because they're an accuser or an accused, but simply because for some reason or another their name appears in those files. And so it's a much broader category than just those who are making complaints or those who are the subjects of complaints. This information, for the reasons that Catherine discussed, can be easily disclosed once turned over to the government, to other actors in the government, to other agencies, as she described, but also to Congress. And this can enable further fishing expeditions. The information can also be leaked to the media as Congress congressional subcommittees have done, disclosing internal communication, email exchanges, names of individuals, et cetera, by posting them on congressional websites and inviting the media to scrutinize and run articles detailing that private correspondence as a consequence of files that were turned over in the course of these kinds of investigations. What these resolution agreements have produced is a kind of audit culture through which the government can continue to indirectly regulate campus conduct through repeated demands for information and an expansion of enforcement agendas that I think may have begun in some instances in the expanded enforcement under the Obama administration in the Title IX context. But notice that under Title IX and Title IX resolution agreements, there are far more extensive procedural protections available for individuals that are accused in any way under those under that statute here and under those regs. Here, none of those procedural protections attach, and the persons that are facing accusations are being accused of either being pro-Palestinian or critics of Israel, which in this current political climate means the likelihood that they will enjoy procedural protections or that anyone in government will demand that they be given procedural protections are vanishingly slim. The pledges that universities have entered into in connection with resolution agreements concerning shared ancestry are precisely that. None of these kinds of voluntary resolution agreements have required this extensive machinery I've just described, this pattern, agreeing to all of these additional terms, pledging to require campus police to report allegations of discrimination, policing speech on campuses, entering into campus climate surveys, mandatory trainings. All of this has been exclusive to shared ancestry, by which I mean racial discrimination, the kinds of discrimination that Title VI historically has been designed to protect against, are not subject to these kinds of resolution agreements. This is only applying essentially in the anti-Semitism context. And if we want to understand why an anti-discrimination agenda this expansive cannot be reconciled with free speech, it's useful to take a look at particular examples. I'll just give the example of Lafayette College, which FIRE, the First Amendment free speech think tank, put out a detailed analysis of the sort of circumstances under which Lafayette College ended up entering into a resolution agreement. This college took every step that they were recommended to do from the guidance provided by the Department of Education's Office of Civil Rights, with one exception. They did not agree to censor campus members' use of social media or speech in extramural context. So they addressed every complaint that was brought, they offered mediation, education, they took every step available to them short of direct censorship in responding to the kinds of speech that they deemed or complainants deemed might contribute to a hostile environment on their campus. And despite taking all these measures, responding individually, calling people into offices, offering mediation, running educational programs about the hurt that might ensue from using certain kinds of speech in social media or other extramural contexts. Despite taking all of these measures, they were nonetheless found to be in violation and required to enter into one of the resolution agreements. And so basically there isn't a way of evading the sort of, let's call it the strong arming through resolution agreements to adopt these much broader kinds of regulatory measures and continuous production of information to the government once one of these complaints is filed and an investigation is undertaken. What I think, in sum, I would say then, is that the Biden administration either used or allowed Title VI to be used as a cudgel to crush student-led protests in support of Palestine through this shared ancestry mechanism and the broadened definitions of anti-Semitism that allowed anti-Israel or criticism of Israel, criticism of Israeli policies and actions to be turned into a language that would be framed in terms of anti-discrimination. But that has now become something quite different under the Trump administration. So what was once a cudgel is now essentially a battering ram to remake American higher education under the Trump administration. And a good example of the contrast is Brown University, which entered into a resolution agreement under the Biden administration and then was compelled to enter into a second deal with the Trump administration that went far, far further, as has already been alluded to in the presentations Catherine and Brian both gave. Tens of campuses have released names beyond the UC and other UC, beyond Berkeley and other UC campuses. As Leslie mentioned in her opening, other UC campuses haven't even done their community members the courtesy of informing them when their names have been released, and none of the campuses has agreed, including Berkeley, to share with those whose names were released the circumstances under which their names were released or redacted versions of the documents that were produced to the government. So as Catherine mentioned, what would be the best practice? What might we hope our campuses would do going forward? First, demand to anonymize any materials that are turned over in these investigations. If that is denied, consider litigation. It is not clear, for the reasons that I think have been made clear by both prior presenters, the purpose of Title VI anti-discrimination enforcement is to ensure that institutions are complying with their obligations. There is no obvious reason why personally identifying information about any individual involved in these complaints has any bearing at all on whether institutions are actually complying with their enforcement obligations. There is no reason, apart from the one that Catherine mentioned, which is improper delay, and it's very simple for campuses, I think, to anonymize this information without engendering improper delay. But if they're willing to anonymize and they're going to go to the trouble of doing so, and that option is denied by the Trump administration, they should litigate. And the reason for that is because those who are named are exposed to a radical environment of risk today that not just chills their speech and chills their academic freedom, but threatens their employment, threatens them with doxing, and threatens inviting much further and much more far-reaching measures against them from this administration, as our litigation AAUP Rubio made clear. And I'll stop there.
So thank you. Thank you so much, all three of you, for those just really complex and fascinating, and yeah, so there's so much information there for us to think about. I thought it would be interesting to have each one of you comment on the other panelists, just briefly go around, and then we'll open it up for a larger discussion.
Yeah, I mean, I guess I want to say at the outset, I love Asli. We were law school classmates, and I appreciate the passion that you bring to this work. I do strongly disagree about whether and how the Biden administration or the Obama administration used Title VI for its traditional race enforcement. We resolved 5 times as many shared ancestry cases as the prior administration, the Trump administration, had resolved, and more than any other prior administration, because we received so many more cases than we had received many prior times. We resolved, I now have forgotten what the total number is, but 50, I think, total cases related to shared ancestry in the 4 years of the Biden administration. And we resolved many thousands of cases related to race discrimination. So, you know, a concern I have is that the news reports what it reports, and there was a lot of news reporting about the tiny subset of cases that were shared ancestry allegations that we received, as compared to the many more straightforward race harassment, race discrimination cases that we also resolved. But the degree to which we were cudgeled in a handy way. And I was pleased to be cut, so I'll accept that. The resolution agreements themselves are designed not to chill speech, but they are designed to make sure that our campus communities understand the non-discrimination obligations. And it was shocking to me to learn, as a lifelong civil rights lawyer, as a longtime federal civil rights enforcer, how many campus communities had not understood the broad scope of their obligations with respect to speech. And it is that you cannot discipline a speaker for protected speech, and we never asked anybody to do that. But there are steps to take, separate and apart from discipline of the speaker, to ensure that the campus community is safe. And the obligation to evaluate the totality of the circumstances, the obligation to evaluate whether speech or any other conduct contributes or creates a hostile environment that requires redress, is a long-standing statutory obligation of our school communities. And what we saw in the files is that they weren't doing it. And to pick up on Lafayette, which you mentioned, one, I don't think we made a finding, I think we had a resolution concern. But two, we did not think that the speaker should be disciplined. We did think that the university misapplied the law because it did not consider the totality of the circumstances, and it did not consider whether the speech contributed to hostile environment. And that is what we sent the university back to do. So that to me, a gross outcome of October 7th has been a revelation about how many of our educational institutions hurt our kids and hurt our institutions because they allow people to learn in hostile environments and they don't redress the injury. And that's true with respect to race, that's true with respect to national origin, that's true with respect to sex, that's true with respect to disability. And our law guarantees otherwise. And I'm delighted to be aggressive about changing that and changing that on campus communities. On the issue of the Office for Civil Rights responding to journalists, responding to people who are not themselves actively involved, and having to respond to whoever is trying to wag the tail. That's a real concern. It's a real concern because a beautiful guarantee is that the office will investigate whenever it has information that the law may have been violated. And there's not a standing requirement about how the office runs that information. So that means anybody can come with a back of the napkin complaint and tell the Office for Civil Rights, and the Office for Civil Rights will answer that question. That's hard on the staff, but it's a really good principle to try to make sure that the law applies equally to everyone. And just to give some data, there's a particular complainant who, over a roughly 10-year period, filed more than 37,000 complaints related to school athletes and Title IX. And so the 15 complaints that we got from a single journalist pales in comparison to the people who were trying to wire them. But I think there's a very real concern about what the takeaways are, separate from what I think is a principal lawyer who's a civil rights expert who lives this work every day, to what gets reported in the news and what gets understood by people who are living the experience and feel themselves persecuted, feel themselves maybe underprotected, and feel themselves insufficiently guaranteed the rights that Congress gave to all of us. And I think that's a real concern that is worth a real worry. I believe in using our civil rights laws aggressively to protect as many people as we can. And I was delighted to work on the expansion as you described it also, which I don't think is an expansion, I think it's just a correct interpretation of Title VI about the ways that it protects all of us. But I also think it's important to make sure that all of us understand that it's even-handed, that everyone is protected, that this is not political, and that the job of the federal government is to make sure that no person experiences discrimination. And I was aggressive about trying to push that. I regret every day that I am not there now, still to push it, and I think we live what gets reported in the news again, and that is often not all the people.
So do you want to just jump in and respond directly?
Sure, yeah. Well, there are a bunch of things to say. I think that one element of hostile environment, of course, is like a subjective assessment of what constitutes hostility. And one of the challenges, and I think Catherine, you know this well, and I share my great respect for you and the work that you've done. But the context in which all of this was arising in the post-October 7th environment was one in which, for a variety of reasons, Palestinian, Arab, Muslim, etc., complaints were chilled in ways that made it impossible for everybody to benefit from the shared ancestry, zealous enforcement that you're describing. But it also meant not only were they chilled, generally speaking, from coming forward, but also it came to be the case at colleges, including places like Lafayette College, that simply asserting that identity or asserting your views from that identity perspective itself constituted a part of the alleged hostile environment that people are operating in. And so for one set of communities, it meant that their assertion of their identity or the perspective that they had on the conflict was itself presented as a form of discrimination. And that depends upon the two legs I mentioned of this strategy. The first of which is the expansion to shared ancestry, which left on its own for years, as it was until the first Trump administration, without an expanded definition of anti-Semitism that encompasses criticism of state action and policy, was, as you say, might have been best interpreted as a way of expanding the protections of our civil rights to all forms of discrimination. But when you add a component that basically introduces, let's say, an ideologically contested understanding of discrimination, and then that's wielded by the federal government in an increasingly indiscriminate way, and the indiscriminateness being driven by the number of complaints, which I acknowledged at the outset, right? The number of complaints shot up dramatically. You had more complaints in 2 months in 2023 than ever in the history of the office until that point, and then more complaints yet in every subsequent year, complaints themselves being driven by an environment in which those complaints could be magnified dramatically, not just by actions by the administration at the time, but by donors and alums, by the reputational harm that was being done every time an investigation was opened. But I think to fail to appreciate the ways in which that can indeed, and in the political climate we were in, that must be in tension with the ability to protect academic freedom and freedom of speech, at least for those of us who are scholars of the Middle East. To be blind to that, I think, is just, I can only describe it as naive. The other thing I would say is, towards the end of the Biden administration, and certainly entirely now under the Trump administration, the uptick in those investigations has crowded out the ordinary work of the office doing any work on the remainder of racial discrimination. What I was saying was not that there weren't also resolution agreements around racial discrimination. What I was saying is the content of those agreements was not nearly as far-reaching, with as much, potential to continue to police specifically widespread forms of campus speech at a time when campuses were seized of a political question abroad, and we're witnessing not just protests, but also events, public events being shut down, film screenings being shut down, classes and syllabi being intervened in, curricula, and now, as you can see with the 160 names that were released at Berkeley, essentially left-leaning faculty across the country facing forms of scrutiny for simply teaching their ordinary classes or engaging in public intellectual work. In that environment, the idea that, this is a politically neutral enforcement machinery that simply treats everybody equally and is about zealous enforcement against discrimination without implications for academic freedom and freedom of speech, I just think is to deny the reality we've all lived. And it's not about what journalists report. I think for those of us who have been living on American campuses over the last 2 years, the portrait that I'm conveying is not one that people have learned through the media, but rather through first-hand empirical experience of it.
Just to be clear, there's no single resolution agreement in the Biden administration that even references the IHRA definition. So, it is true that there are people who particularly love it. There's not a single resolution agreement in the Biden administration that even references the IHRA definition, and there's an executive order from Trump 1 administration that requires all of the federal civil rights agencies with external civil rights enforcement authority to consider the IHRA definition to the extent that it is relevant in determining intent in discrimination. Intent is actually not an element of the hostile environment calculus. So that was a meaningless executive order. The guidance of the Trump administration, Trump 1 administration Office for Civil Rights, was that it didn't change the way the Office for Civil Rights investigated or acted or enforced, and it in fact did not. So I know there's lots of worry about it. I know there's lots of hatred for use of that definition, and we didn't. But and this will not be comforting, but I'll just say it. The free speech calculus with respect to race was probably much more direct with respect to race discrimination. I genuinely don't think that there is a free speech infringement in requiring schools to fulfill the non-discrimination obligation. And we had classroom professors who criticized black students because they're black in front of the class, and we did mandate addressing speech going forward when that happened. So, the issue for me is we have to hold the non-discrimination principle as dear as the speech and academic freedom principle, and I do. And we never ask any institution to discipline any speaker. All of our guidance explain that you cannot satisfy Title VI by requiring discipline of a speaker, and you cannot ignore the Title VI obligation to protect the rights of all people in a school community. And that is the thing that I think what we saw in the records, too many of our school communities were doing was saying this is speech, and therefore there's nothing for us to do. This occurred off campus, there's therefore nothing for us to do. That's not the inquiry. And so it was important, it is important to change our public understanding of what that is, while ensuring that we protect all of us in our school communities.
I think it's important that in an environment where enforcement is so utterly one-sided, our current moment, that we don't lose sight of the things that we actually do care about in anti-discrimination enforcement. And I take it that that's what you're saying as well, Kat. I'm sure all three of us are agreed on that. I mean, Catherine's office under the Biden administration was trying to address a problem specifically of cumulative, a hostile environment that arises through cumulative acts of hateful, hostile speech. And that's a difficulty. Many of our free speech organizations would have it that you could only step in the latter case you were saying, where somebody says something directly that rises to the level of severe or pervasive, and so you discipline that person and do something about it. But that's a speaker perspective. That's not the perspective of the person that's walking through campus, experiencing statements and acts of hostility and hatred from every angle, and not just on campus, but also on their social media, etc. And so there was something I thought, in contrast to many of my colleagues that work for organizations like FIRE and free speech, campus speech organizations, that was really admirable in the attempt to address cumulative discrimination of that kind, cumulative hostilities. Because what we care about ultimately is the experience of the students that are trying to get an education, as opposed to simply care about the free speech rights of any particular individual. Those two things have to be balanced. And it's incredibly sad that having done that, it's now being used, as you said, in a not even-handed cudgeling that this would lead us to where we are now. But we do have to find a way of responding to it in a way that doesn't get rid of the, I think, important equality achievements that were made previous to this.
So thank all three of you for this I guess I want to say I think it's really, really interesting and important to understand the levels of disagreement that people have around how to think about these issues. And I also think it's really important to go back to what Brian was saying earlier, to think about what we want to do internally within our campuses and within the UC system to protect ourselves in the context of these things being an ongoing pressure from the Trump administration. So I want to make sure all those are on the table. And I think at this point what I'd like to do is stop taping the panel and turn this around, and if we could have questions from the audience,